today for our deep dive, I'm going to share my screen with you, and we're going to go to the very exciting Utah law section. So how you get here is you go to Realms, and well, I can show you in case you want to do it yourself. So Division of Real Estate is realestate.utah.gov. And then instead of clicking on Realms, scroll down here and click on Real Estate. And then you've got a couple of different things with statutes and administrative rules. You can look at the act itself, the Real Estate Licensing and Practices Act. It is hard to navigate. If you go to administrative rules, it takes you to this, and you can scroll down through everything, but they are not the same thing. It's not just one's a simpler way to navigate the other. There's different things in here, but this is the easier one to read and navigate through if you want to brush up on a couple of things. So today what we're going to be brushing up on is our 162 2F401A affirmative duties required of licensed individuals. And if we get time, we're going to go down and talk a little bit about some things that you can't do as well. So we're going to skip the first section because I believe I've already done a training on that, and that talks about your fiduciary duties. We're going to jump down to section 2. Now, the reason why I'm picking on this in particular today, define the scope of the individual's agency by execute a written agency agreement. That looks like a typo. A written agency agreement between the individual and the individual's principal. So remember, these are affirmative duties. These are things that you're supposed to be doing, okay? So you're supposed to be defining the scope of your agency by executing a written agency agreement between the individual and the individual's principal, including the sellers the individual represents and the buyers the individual represents. The reason why I'm mentioning this is because we have currently the big NAR lawsuit that most of you are aware of. A big part of that has to do with buyers' agents being devalued or undervalued. And if you want my conspiracy theory on that, I think there are a lot of industries out there that are very eager to get rid of buyer's agents, because if you can just go shopping online through my electronic portal and you don't use a buyer's agent, then think of how much money I can make by cutting out those buyer's agents. And so undervaluing agents, undercutting agents is a big deal. And there are several industries that are highly motivated to do that. So what we need to be doing is, number one, we need to do a better job of, I think, first of all, it starts with providing value. All right. And I want every agent that watches this video or that is attending here, I want them to take a real heartfelt moment and examine themselves. How are you providing value? See, when I interview a new agent that's just gotten their license, I ask them all point blank now. I said, are you comfortable with the knowledge that you got out of real estate school in taking $10,000 to $30,000 of your friends or family's hard-earned home equity with the knowledge that you currently possess from getting your real estate license? And if they say yes, then I say, I don't want you in my office. Okay. In real estate school, they did not teach you how to take care of your clients. They taught you a few laws not to break. Okay. That's about it. They did not teach you how to take care of your clients. And so step number one for me is you have to provide more value than a real estate license. You have to get the education. Okay. Even if it's something as simple as when I, with my training program that I do, the Elite Agent Training Program, which is something that I require for all new agents that join my office. With that training program, we've got very simple steps for when a buyer goes under contract or when a listing goes under contract. They don't teach that anywhere. They don't teach that in CE classes. They don't teach that in real estate school. And so if a buyer were dropped into your lap, you wouldn't know what to do. And so one of the simplest things in there is call and make sure the utilities are turned on. Because if you show up for an inspection and the utilities aren't turned on, the inspector's frustrated, your clients are frustrated, everybody's paid for something, you might be right up against your inspection deadline, and you can't get a true inspection done. And just having that one simple bit of knowledge that otherwise, if you haven't devoted yourself to being a student of the business, you miss that thing, your clients don't have value. They don't get a good home inspection. They're pushing back deadlines, which if the sellers don't agree to that, then it jeopardizes their transaction. One simple little tiny thing could totally screw up everything. And having a real estate professional that isn't just learning through the school of hard knocks, stumbling through this blindly and expecting to get paid, that's very important. So number one, invest in your education. Okay, invest in your training, because what they gave you in real estate school for $450 is not sufficient. So once you have invested in yourself, number two, communicate that better to your clients, to your buyers, to your sellers. That means obviously when we sit down with sellers, we're doing a listing presentation. Everybody does a listing presentation. Right? We sit down, we communicate our value, what we're going to do, how we're going to get the home sold, our marketing plan, all of this stuff. And yet when I go to some of the Facebook groups that I belong to, groups across the nation, I saw one guy 2 weeks ago, and this has stuck with me, and it just drives me nuts. But I'm not a big fan of engaging into online battles with strangers, so I didn't engage with the guy. But he said, I've been doing this 25 years. I've never signed a buyer agency agreement, and I never will. And I'm thinking, you dumb bleepity bleep. Okay? Why wouldn't you do that? Why aren't you doing a better job communicating your value as a buyer's agent? You're not an Uber driver. You're not a magic key holder that gets people into doors. And yet that's all you're showing people. You need to sit down with them. You need to do a buyer's presentation. You need to walk them through the whole process. You need to let them know how you're protecting them, how you're watching over them, how that contract works, how you understand the contract, because they're not going to be a contract expert overnight. They're relying on you for that. You take the fear away out of this process for them, because this is a scary process. Lots and lots of money on the line, hundreds of thousands of dollars to buy a home. We need to be communicating how we're safeguarding our friends and family through this process. So everybody needs to have a buyer's presentation. If you don't know how to do it, then go to my YouTube channel, watch the training videos. I show you how to do it, how to have a buyer presentation. When you do your buyer presentation, people love it because they love to know that they've got some protection, that they've got somebody looking out for their interests. They love to know that there's somebody that understands all the legal mumbo jumbo in that contract, right? So Utah state law says that we define the scope of our agency by executing a written agreement with sellers and with buyers. There should be nobody, at least in this state, and that guy, I'm sure he was from another state, but in this state, everybody should have a buyer agency agreement or a listing agreement in place before you start working with somebody, not just when you submit an offer. Okay. Now, this is my training. When we talk to the UAR attorneys, they're people that help us and everything. I've brought this up with them directly, and they're like, the law doesn't say that it has to be at the start of the process. You do have to have it by the time you're submitting an offer, but you don't necessarily have to have it at the start of the process. I'm telling you guys in this training, get it at the start of the process. Don't wait till you're submitting an offer to communicate what value you provide, because they've already experienced a lot of scary things that they shouldn't be scared of. You need to be doing more and doing better. Okay, so we're going to get an executed written agency agreement, buyers or sellers. That means we're doing a listing presentation and a buyer presentation. If you don't have those in place in your business, get that developed this week. Okay. Now, in a limited agency situation, which, it refers us down here to subsection 4. We'll get to that in a little bit as well. So you'd have to have an executed written agreement for limited agency. And same thing if it's property management or a tenant that you're representing. So in all of these cases, buyers, sellers, limited agency, property management, or a tenant, we're going to have a written agreement in place. Jump down to 3. If representing both principals in a transaction as a limited agent, obtain prior informed consent by clearly explaining in writing to both parties that they could each be represented by a separate agent, the type of information that will be confidential, the type that will be disclosed, and the circumstances under which the withholding of information would constitute a material misrepresentation regarding the property or regarding the abilities of the parties to fulfill their obligations. Okay. Obtaining a written acknowledgement from each party affirming the party waives the right to undivided loyalty, absolute confidentiality, and full disclosure from the licensee, and obtaining a written acknowledgement affirming that the party understands that the licensee will act in a neutral capacity. So all of this is talking about limited agency. And again, if we went up to section 1 and we looked at fiduciary duty, it mentions all, confidentiality and obedience, full disclosure. Obviously, when we're in a limited agency situation, we can't have full disclosure. So this explains that. The circumstances under which withholding of information would constitute a material misrepresentation regarding the property or regarding the abilities of the parties to fulfill their obligations. What does this mean? What are circumstances? So again, if we're representing both principals in a transaction as a limited agent, obtain prior informed consent by clearly explaining in writing to both parties the circumstances under which the withholding of information would constitute a material misrepresentation regarding the property or regarding the abilities of the parties to fulfill their obligations. What does that mean? Anybody? Let's say that I'm representing seller and buyer. Seller, we walk through the home and they mentioned that there's a couple of, maybe there's some foundational cracks. Okay. And they're like, we're gonna paint or let's do another one because foundational cracks aren't common, but water leaks in the ceiling from an old leak. Okay. The upstairs bathroom, kids clogged it. It overflowed a little bit. There's some discoloration on the ceiling tiles in the basement, on the sheetrock in the basement. They're going to, we pointed out on our walkthrough and they say, oh yeah, we'll get that taken care of. We're gonna paint over it. What kind of a discussion should we be having with both the sellers and the buyers?
Disclose it.
Okay. This is that would be a material misrepresentation regarding the property. So we need to have this discussion with them. If we're just painting over it to hide it, that's a material misrepresentation. We can't do that. We need to disclose this. It's a material fact about the property that there was a leak, that it happened, and you can paint over it to make it look better, but we do need to include it in our disclosures and mention it. Okay. What about regarding the abilities of the parties to fulfill their obligations? This can affect buyers. A buyer, we find out they can't qualify for the loan. Now, granted, there may be other options open to them. And so you'd have that conversation with your buyers first. Like maybe they can cash out their 401k. Maybe they can get a cash gift from their parents. But if they can't fulfill the terms of the offer at all, then we're going to need to disclose that. Okay. So there are circumstances under which the withholding of information would constitute a material misrepresentation. And that material does carry over to buyers as well, because a buyer's ability to perform is a material fact that is defined here as Utah law that needs to be disclosed. Okay. And then obviously we can't provide undivided loyalty, absolute confidentiality, because there's certain things we can't say. So let's say that you are representing both parties and the buyer says, well, what do you think? We like the house. What should we offer on it? What's your answer? Anybody? Okay. Nobody's going to guess on this? I guess this is being recorded, so you don't want to step out on that branch. Our answer is, I think, asking price. Why is that our answer? Because anything else violates our fiduciary duty to the seller, right? Now, I had this conversation with one of my agents this week, he's in this situation. And to complicate it even further, he's related to one of the parties. They're like a first cousin or second cousin or something. Okay. So he really is treading lightly around this. He wants to make sure that both parties are treated fairly. And so I said, you could have the discussion with your seller and say, you know what, everybody wants a little bit of a deal. Would you be comfortable with me saying, you know what, I've talked to him and he said he'd go $5,000 off of asking price for you. You know, otherwise, when we're filling out this offer, you know, they're going to ask me, what do you think we should offer? And if I just tell them full asking price, they're not going to feel real good about that. So you can go to your seller and you can have the conversation, and then you can go to the buyer and say, you know, I had a conversation with the seller about this, and they said for you, they'd be willing to go to this price. And of course you would want to get that in writing, right? So after that conversation, you could say, you know, I'm going to email you just so I have a record of this. So you just say, as per our conversation earlier, can you just confirm that you said it's okay for me to tell the buyers that they can offer this price on your home? All right. So we can have that conversation. Otherwise, when the buyers ask and say, what do you think we should offer? Your answer has to be full asking price. Anything else is a violation of your fiduciary duty. Okay. So you have that conversation with them, with the seller. Then you go and you have that conversation with the buyer and say, I had this conversation with the seller and they said we could do this. Now both parties feel good about it. All right. And if the buyer says, you know what, we want to try offering lower, great, I'll write it up. And then you go back to the seller and say, you know what, I did tell them what we discussed. I didn't encourage them to do anything other than that, but this is what they wanted to offer. Okay. And we're just the neutral third party going back and forth. So that comes down to number 4. When we are in a limited agency agreement, we are a neutral third party. All right. And we have to be very careful about upholding the fiduciary duties to both parties. So obedience, we're obeying any lawful instructions from the parties. It is not lawful to hide material facts. So we're obeying lawful instructions consisting with the agent's duty of neutrality. We've got reasonable care and diligence still in place. We're holding safe earnest monies, any additional duties created by the agency agreement. All right. So I wanted to go over this section here, 2, 3, and 4 in particular today, because of these national lawsuits that are out there. And I want to encourage us, number 1, to provide more value than your basic license teaches you. I want you to do a better job of communicating that value to people that you're working with and do it right up front. Okay. Don't catch yourself sending out hot sheets to people that you don't represent. You need to be sitting down, doing a presentation to them, understanding, helping them understand that, hey, I'm going to be providing these to you once you're pre-qualified. What good does it do to send out hot sheets to somebody that's not pre-qualified for that amount? Right? Agents do a lot of stuff because they're afraid of confrontation, but we need to be better than that. And we're not afraid of confrontation because it's not confrontation. It's us communicating value. And if you're afraid of communicating value because you don't think you have much value, then let's get you trained so that you have value. Because a good real estate agent, even with those simple scenarios that I gave you about making sure the inspection goes smoothly by having utilities turned on, that is the simplest little thing that you can do. But it could be the difference between the deal closing or not. Okay. Understanding how to write up the contract, you know, things we can ask for, things we can't ask for, things that are going to trigger an underwriter to automatically dismiss this or get involved and change the terms of the contract. Things, you know, ways to write up the address so that we open ourselves up to a possible appraisal waiver. You know, simple little details like that that can save a deal, that can save your client hundreds to thousands of dollars. These are things that agents, these are values that we provide in every single transaction, potentially. But if you're out there operating with the basic knowledge you got just to get a real estate license, you're not providing that value, and you need to take your career more seriously. Okay. The reason we can get paid the amounts that we do is because we're providing a value equal to or greater than that value of that commission. It's because we're saving deals. We're saving people tens to hundreds of thousands of dollars. They don't know the laws about material misrepresentation. Those laws apply to them whether there's an agent involved or not. You know, they could be out there covering up things, not disclosing things. They don't understand it. You know, we've seen people get sued for hundreds of thousands of dollars for failure to properly disclose information. These are the types of things that we save them from. And those are worst case scenarios. Even in a normal scenario, we are out providing value about, you know, properly pricing the home, the negotiations, you know, avoiding the personality conflicts that derail so many transactions because people are either too friendly and so they don't put things in writing, or they make a comment that offends the homeowner, you know, about their carpet or their choice of colors or something like that. I want to jump down now to prohibited conduct. Okay, this is the next section in the law. Prohibited conduct as applied, as applicable to licensed individuals. An individual licensee may not, and then we've got a whole bunch of things. Okay. Basically, let's see, we're going to jump down to let's see, sorry, I had in mind, I just have to find it here. Okay, this is one that comes up occasionally. We're going to start down here with D. Propose, prepare, or cause to be prepared a document, agreement, settlement statement, or other device that the licensee knows or should know does not reflect the true terms of the transaction. Okay, so either proposing it, preparing it, or causing it to be prepared, basically a fraudulent document. All right. Knowingly participating in a transaction in which such a false device is used, or participating in a transaction in which a buyer enters into an agreement that is not disclosed to the lender, or if disclosed, might have a material effect on the terms of the granting of the loan, or use or propose the use of a double contract. So a lot of this defines a double contract. Okay, we've got one contract that the lender sees, we've got a separate contract off to the side that the lender doesn't see. This type of thing, you might think, you know, fraud is uncommon. Fraud itself is uncommon until we get into people innocently committing fraud, and then it happens all the time. Okay. One of the things that I hear about a lot, and title companies either don't know this law, or they're unknowing, or they're participating in it. But I've been to closings where they said, hey, you know, we've got this separate issue with the home, and the sellers are just going to leave $5,000 cash here with the title company for you to, you know, take and fix those issues outside of closing. If the lender knew that the seller was giving the buyer $5,000 cash to take care of an issue outside of closing, would the lender approve that loan? You guys that are experienced, what do you think?
No, they would not.
No, they wouldn't. Okay, so right here, we're participating in a transaction in which the buyer is entering into an agreement that is not disclosed to the lender, and if it was disclosed, the lender wouldn't give them that loan. Hey, I'll just give you $5,000. I'll just leave it here with title. I'll put it on the counter at the home. You take care of those issues yourself. Okay, that's not okay according to the law. So what happens if that scenario took place and we had this separate side agreement, but we didn't put it in writing because, hey, once we put it in writing, now we've got a double contract, right? So we don't put it in writing. We just have this understanding that there's going to be $5,000 there on the counter. What happens when the buyers move in and there's no $5,000 on the counter? Now they're like, hey, we were supposed to have $5,000 on the counter. Where? I don't see that in the contract. And now everybody's pissed, getting attorneys. And now not only do you get sued, but now you've committed fraud or perpetrated in the fraud. You've knowingly participated in a transaction with a false. So all of these things come out, and it's bad business. Okay. And yet these things are very common. And it comes from an uneducated realtor. So we go back to what we talked about at the beginning. What would a great agent do? A great agent would know how to navigate all of these things, right? We're not relegated to using a false device because we simply can't think of a better solution. We've been through trainings, we've gone to the classes, we've watched the videos that hopefully you guys are watching now, besides those of you that are here live with me. We understand that there are better solutions than double contracts, than fraud, than false devices that could not only get us in trouble, but could get our clients in trouble. And here's the thing, you guys, is that without an agent involved, clients do all these things as well, and those things are still illegal. Okay. If it's an unrepresented buyer working with a for sale by owner and they're negotiating back and forth and they don't know any better, is it still fraud? Are they still deceiving the lender? Because if the lender knew about that, they wouldn't give the loan. Yeah, that's still fraud. We've got buyers and sellers participating in fraud that if it comes out, they could both be, have serious issues. So it's not because realtors are involved that all of a sudden these laws apply. Realtors should know the laws and protect people against them. That's one of the values that we provide. Now, was this taught in real estate school? Maybe, maybe not, probably not in this kind of detail, which is why we do our deep dives. All right. So how do we handle these types of things? Well, we do a different training on how to negotiate repairs. That's kind of what we talked about. That's where a lot of these false devices come about. And so we do have a different training on how to negotiate repairs, how to use the correct paperwork. And so I would encourage you to watch those. But the things that I want to stick with you is if you're a part of a transaction where they're proposing a false device or a secondary agreement that's off to the side, whether it's written or unwritten, and if it's unwritten, don't think for a second that you're not going to get in trouble. If your buyers and sellers think there's an agreement, doesn't matter if it's written or unwritten. If it's not acted on, then they're complaining, and it comes out that you're trying to perpetrate fraud. If it is acted upon, then the fraud is there. Everybody can see it. It happened. Anyways, protect yourself, protect your clients, and get the knowledge and education. And I've demonstrated today, and I'm going to try to keep this video concise to this point. What I wanted to demonstrate to you guys is just a couple of ways that we can provide value. Do you have issues come up with almost every inspection? Yep. What are the scenarios when you don't have issues come up with an inspection? And I'm thinking for sell by owners. Okay. I've listed my home $50,000 below market value. I'm probably the only one that's not aware of that fact. But all the realtors like, holy cow, this one's a great deal. These guys don't know what they're doing. There's a few real estate brokerages out there that you guys know of that do this same thing. They're the rebate ones. They don't come out. They don't walk through the property. But hey, we'll put your home on the MLS for $500 or something. It's because they didn't provide any of this value. So we look through those companies, and every once in a while we find that gym, they're priced $50,000, $75,000, $100,000 too low. Do we raise a fuss with the inspection report? No, we pull our clients inside and say, hey, you know what? This is going to be $500 to fix. We're getting a deal of $100,000 off market price here because these guys don't know any better. Let's not make waves. right? So when I see a for sale by owner and they're like, oh yeah, I've sold my own home 3 or 4 times, I've never had a problem. If you've never had a problem, this is why. Because otherwise, if you're at full market value, every time an inspection report is done, guess what? Issues are raised, right? Every transaction involves these types of things. And so a great agent knows how to navigate them. They know how to negotiate. They understand this portion of the law, how we're not tempted to go into forbidden, fraudulent schemes to get around it, to get around the underwriter. We don't write into our contracts language that would trigger underwriters to do or force expensive repairs, things that maybe a seller can't do, which would kill the deal entirely. All of this knowledge is things that agents do to provide value. Do a better job of communicating that. You guys are worth it. Okay, you're worth the commission if you're investing in your knowledge. If you're not, you're simply not worth the commission. You should probably get out of the business, right? But if you are a student of the business, and if you are learning these things, that's a very simple example of how you could save your clients not only multiple thousands of dollars, you could save the transaction entirely, you could save them from committing fraud. That one item alone is worth your commission, right? And that is not the only item that we deal with. So do a great job of communicating your value out there. Thanks, you guys, for joining us today. Happy Halloween to everyone. I'm going to stop the recording.